Hi, welcome to Your Future, Your Finances. We have a great show for you today. We're going to be talking about estate planning and elder law. We have two great guests for you. My first guest today is Kevin Bress of KP Law, based in Columbia. Welcome to the show.
Thanks, Brian.
All right. Tell us a little bit about your show, your background and your firm.
I've been an estate planner for about 30 years, as much as I hate to admit it. And we have an office in Columbia, as well as Towson, and just generally do family planning for people, whether it's a basic estate or a lot of times a family member needs long-term care. And so we give advice on keeping the family protected the best we can.
What's going on in the world of estate planning these days?
Well, it's rare that there's anything exciting. You can talk about tax rates and exemptions, but kind of interesting in Maryland, coming up October 1st, a new law about what they call digital assets, and put in late terms.
Is a Maryland law.
Maryland law.
Okay.
And it's dealing with things like social media, Facebook, but some people don't get involved with that, but they might have email, or they order on Amazon.com. Well, if a person becomes mentally incapacitated or dies, that account could be frozen, and often you haven't given your password to anybody, or you've changed it so many times, you have trouble remembering what it is. Who has access to your, as they call it, digital assets? And now a law in Maryland is going to allow people to put in their power of attorney or their will, an authorization that says, hey, Facebook, my wife is allowed to access my email account, my online banking account, because right now my wife wouldn't have a clue. She'd be typing all year trying to hack into it. So I think that's a positive.
And this is a Maryland law as opposed to national law, so specifically residents of Maryland.
It's a movement. So a lot of states, there's some uniform digital asset act floating around, and Maryland's just getting on board with it.
But once that passes, the sites themselves, they have to agree, I suppose.
Time will tell. The sites tend to tell you what to do, but certainly this gives you the clout, the legal clout to push. And I say to my clients, look, all this law stuff is great. Make sure somebody in the family knows the password. Keep a little book somewhere or something, because why have to go through the legal department of Google when you can open up the drawer and look up the password? Yeah,
so you actually have like executors of estates contacting the legal departments of these sites to shut down their accounts. I can imagine that's a headache, not that an executor needs another headache. But that could be a lot of work.
Right, and shutting down is the key, because I had a family say it was just so upsetting that their people are posting messages to their dad's account, and he's passed away, and it's like, I don't want to see that stuff. I want to close that down.
And so this would be something that you write into a will. So does that mean like every will would need to go back and be rewritten?
I've started plugging it into mine. The language is fairly clear as to what it needs to say, and so people should be putting that on their to-do list at some point. It's hard to say everybody needs to rush in and change their documents, but certainly that's one of the excuses to do so.
Yeah. Another big thing with families is the home, right? So they own the home. What do they do with the house to make sure from an estate planning standpoint things go smoothly?
Yeah, I've 30 years of doing this, I start to see and have enough war stories that I've kind of changed the way I do business with clients on the house. Because most clients will say, oh, I have 3 children and I'd like to leave that all my assets equally to my 3 children. Well, a house going to 3 children, here's what I've seen happen. One child says, okay, we're going to sell the house. I got a realtor. We're going to fix it up. The second child says, oh, no, you don't. I'm moving into my 1/3.
I'm already in the basement, right?
I got the whole basement claimed. That's a third. And the third child says, well, I hope you like Chester, because I'm renting my third to the guy I went to college with. And so this is a potential nightmare. And the law in Maryland is that if there's a house to be distributed in an estate, you're supposed to distribute it as is. The estate's not supposed to say, sorry, we're going to sell it. So we want to put
So
in the
it's not,
will.
I'm sorry, so it's not in the executor's discretion whether or not to sell it?
There's usually language that says you may, but it's not clear. And so I like to make it clear in the will, the executor shall sell the home unless the children agree to how to distribute it. And I let them sell it to a child or distribute it to a child at a discounted value. Why charge full value for it? So this is a good discussion item in families with more than one child.
I get asked a lot whether to put the kids on the deed. Does that come up to you a lot?
All the time.
Yeah. What do you think of that?
Well, they don't always understand there are two ways to add names to a deed. Co-ownership, which is the disaster,
Okay.
because a lien against a child's assets includes their ownership interest in a property, or something called a life estate deed, which is equivalent to naming the children as beneficiaries on the deed. So you're adding their names, but you're not adding them as co-owners, and I think that's the way to consider.
And that can be done in Maryland, and that would be something they would reach out to an attorney like yourself to do?
Yeah, deeds are the province of attorneys. It's not a do-it-yourself kit, unfortunately.
Yeah. All right, lots to get to. We only got to a couple of the topics. We'll be right back. We're talking with Kevin Bress, estate attorney and elder law attorney in Maryland. We'll be right back. You're watching Your Future, Your Finances.